Hello, good afternoon, and welcome to The Law. This is your Legal Light. It is your help law. I'm Samson Ladianyanini, and we are looking at oral in the eyes of the law. Oral stands for Operation Recover or Loot. It's a manifesto promise of the NDC, which the president is presently implementing by setting up a committee chaired by Samuel Okudzeto Ablakwa. But they have come under siege. Many have said they are unconstitutional, they are unlawful, they are illegal, that committee ought to be abolished. But there are others who insist that the committee is just the best that we can have. 700 petitions and complaints so far. Will oral survive in the eyes of the law? We'll be right back. You're welcome back. Joining me, I have two guests. We begin with Professor Stephen Kweku Asare. You know him popularly as Kweku Azar, an advocate of good governance in this country and constitutional adherence. He insists that oral has come to stay, and he actually proposes means by which that committee ought to be retained. Prof, thank you so very much for making time to join us.
For having me once again. I appreciate the invitation. Great.
It's interesting. I was wondering that if, even before we start, if you had a comment on the Constitution or composition of the Constitution Review Committee by the President. That has just been announced with your very good friend, Professor H. Kwesi Prempeh as a chairperson, and they have 5 months within which to submit a report and actionable, as it were, roadmap for constitutional amendments.
Yeah, Samson, I just saw the press release a few minutes ago. You know I'm still in the US, so it's a 5-hour time lag, and I woke up and I saw it. And of course, you know my views on the Constitutional Review Commission, and also you know that the Supreme Court has spoken on that. So it's law that a president can set up a Constitutional Review Commission. Of course, as you said, I know the chairman, Professor H. Kwesi Prempeh, rather well from our days in school. We were in the same school, we were in the same hall, we were on the same F block. We carried cocoa or evacuated cocoa together. We went to one of the graduate school here in the US together. So I've known him very well, and I'm keenly aware of his constitutional acumen. If there is anyone who can identify the strengths and weaknesses in the Constitution, then it's probably him. So I'm very, very happy that he's involved, and I congratulate him. At the same time, I must also congratulate another vandal, Alhaji Tanko, who is also, you know, like I said, a vandal, Commonwealth Hall, but also the same course, School of Administration. So it's a good day for University of Ghana, for Commonwealth Hall, for the School of Administration, to have both the chairman and the member of the commission. I wish them well.
And the two make 2 CSO leaders in there.
Exactly.
Because Tanko is involved with Star Ghana.
Exactly, he's involved with Star Ghana, and I've done some work for Star Ghana as well. So I'm very happy that this is happening. Maybe the president, being a vandal himself, has something to do with it, but you never know. These are very competent people in their own right, and I'm glad to see them being used for the betterment of the country.
Right.
That's what is important.
Will 5 months not be too short? They are going to look at the 2010 process and then the 2023 process as well, before they come up with that, what they have to?
Personally, I think 5 months is too long. If you give me 1 week, I'll be able to come up with what is wrong with the Constitution. We need caps on parliament. We need caps on ministers. We need caps on districts. We need to elect our district executives. We need an independent emolument committee. And everything else is just mainly can be solved through statutory reform.
All right.
What ails the Constitution are few key things that must be resolved. The idea, if you look at the 2010 Constitutional Review Commission, they produced about 1,000 pages, but in that 1,000 pages, 600 pages were devoted to, we agree with what is in the Constitution. We agree with what is in the Constitution. Well, why are you even looking at things that you agree with? Let us identify the things that are in the way of good governance and resolve them. And there are not that many things. They can come out with it very quickly.
Right.
Professor Prempeh has been talking about some of these things for decades. And so for him, I don't think he needs 5 months to tell us where we need reform.
Right. Thank you very much for those preliminary comments on the Constitution Review Committee just set up by the President. And now we go to oral, and you say that the President does not need a law to set up a committee to receive complaints of corruption, waste, or stolen public properties because the Constitution and existing legal frameworks grant the President broad executive powers to create advisory or investigative committees. This, your view, runs counter to what particularly members of the NPP in Parliament and some other lawyers suggest, that this is an unconstitutional creation and should not be allowed to continue.
So what a funny country. I mean, it's interesting that we are talking about the President's power to set up a committee to collate information on financial wrongdoing, when a few minutes ago I was congratulating people who the President have appointed to review the Constitution without any law backing it. I mean, clearly, if the President can appoint a committee to review the Constitution, he can also appoint a committee to collate information on financial wrongdoing. But let's go through the Constitution to see some of the sources of power for doing this. And the convenient place to start is with the preamble. In the preamble, they highlight the importance of accountability and probity. Now, how can accountability be important when the person charged with charged with basically the maintenance of the Constitution, the President, the Chief Executive, does not have the power to even set up a committee to collate information on financial wrongdoing so that he can effectuate policy to stop that? Second, going into the Constitution itself, starting with the executive power, Article 58(1) says the executive power is vested in the President. What does it mean to vest executive power in a President? It means he's in charge of the management of the public resources of the country. And if he's in charge of the management of the public resources of the country, then he has the implied power to take any actions that help him to do that management. And one of that is to be able to set up a committee to say, hey, go find out where public resources are being looted. Then let's travel further. If you go to the corruption, anti-corruption mandate, which I think is somewhere in Article 36(8). I may be wrong with the numbers because I don't...
Prof, if you could hold on briefly, you just referred to Article 58, which is that which says that the executive authority of Ghana shall vest in the president and shall be exercised in accordance with the provisions of this constitution. Underlined, exercised in accordance with the provisions of this constitution. And then the law says that the constitution, that the executive authority of Ghana shall extend to execution and maintenance of this constitution and all laws made under or continued in force by this constitution. Now, subject to this, the president may exercise the executive power by him either directly or through officers subordinate to him. Is this what you are pointing to?
Yes, absolutely. That's what I'm pointing to, that you cannot vest executive authority in someone and then turn around and say that person does not even have the power to form a committee to collate evidence on financial misconduct to help him develop policy.
The Constitution says he's going to exercise this power directly or through officers subordinate to him. The people who are on this committee are not officers of the state. And at the time he set it up, he was not sworn in as president. Does it make a difference?
No, it doesn't make a difference, because these people will start their work when the president also takes office. I mean, the president can make nominations even as a president-elect. But we understand that these people have to be vetted and they are going to be sworn in when they are going to start doing their work when they are sworn in. But many of these things are preparatory, and when a president wants to hit the ground running, as soon as he's confirmed as the president, he starts doing a lot of things. In addition, the state security start guiding him, even though he's not president and he's president-elect, because we all understand what de jure and de facto is going to happen a few weeks or a few days from when the
okay, so proceed to the next other provisions you are going to refer to. But you have said that we are arguing about this, but we have a president who has just set up a committee to review the entire constitution, and there is no law backing that. Many will say that the law backing that is found in chapter 23, particularly article 278, where the president has power to set up a commission of inquiry for any purpose.
Well, this is not a commission of inquiry. We know how a commission of inquiry is set up. A commission of inquiry is not just set up by announcement. It's set up by a constitutional instrument, and it has to go through a whole lot of things. So this is not a commission of inquiry. This is a committee very similar to oral, the oral committee. And I'm arguing that if the president can do that, then clearly, setting up a committee to collate information on wrongdoing is something that is entirely within his mandate under Article 58. And then you also said I should proceed. So I would want to mention the anti-corruption mandate, which can be found in Article 35(8). That article mandates the eradication of corruption and abuse of power. And this committee is collecting information that the president can use in the enforcement or in the maintenance of that Article 35(8). Then there's also the oversight responsibility under Article 36(2), where the president is charged with safeguarding public property. Then you have Article 257, where he's charged, where he's supposed to be a trustee of public land and resources. And then you even have Article 41F, which imposes a duty on citizens to expose wrongdoing. And one way of exposing wrongdoing is to channel these things to the committee that has been set up by the president. So from a constitutional standpoint, there are many articles that can justify what the president has done. But there's more. You can go to the statute.
For example, you refer to, for example, Article 35, Clause 8, which says that the state shall take steps to eradicate corrupt practices and the abuse of power. All of that must be done within the Constitution. We have Chapter 5, which calls on the executive and all other persons to respect the fundamental human rights of people. We have also the the chapter 6, that also has a similar requirement for, respect for the Constitution. So how does he do it in the face of the complaints that this committee doesn't have the power or legal mandate to invite people, to question people, summon people, and the rest of them?
Well, but that's what I'm saying. They are giving the dog a bad name just to hang it. Because the president was actually very explicit that once he was elected, many people started calling him with complaints of looting. And because he has to do so many things, it's very difficult for him to keep track of all these complaints. So he says, I'm setting up a hotline. The oral is almost like a hotline. I'm setting up this intelligence hub. If you have complaints, rather than direct them to me, please send it to this hub, this intelligence hub. Then, of course, because everybody can send a complaint, that hub, that oral, has to have a way to validate some of the claims. And so, for instance, if somebody claims somebody is building in the ocean, well, I mean, you can't just pass that on. You have to go and verify. Is that even possible? So what the oral committee does is just to validate some of these complaints that are coming to them. And then once they are validated, they will then channel it to the proper authority for investigation, for prosecution, and whatever the case may be. So oral does not have the power to arrest. It hasn't arrested anyone, to the best of my knowledge. It doesn't have the power to detain. It hasn't detained anyone, to the best of my knowledge. It hasn't really called any suspect to question, to the best of my knowledge. It hasn't attempted to prosecute anyone, to the best of my knowledge. So look, a lot of people give a dog a bad name just to hang it. But let's be clear that oral, at least the concept, is not new. Every time we elect a new government, there's some form of oral. And that happens because in this country, regime accountability is very scarce. And by regime accountability, I mean the tendency for a government in power not to hold its own members accountable. And because of that, there are complaints. People complain, this person has amassed this type of wealth, this person has amassed this type of wealth. And so you would see that opposition parties are always campaigning on an anti-corruption flank. Once they come into power, then because they've campaigned on that, then they have that mandate to investigate the things that they claimed were happening. So what oral is today is nothing different from what General Safo was doing. In the case of General Safo, he even invited foreign agencies to help them investigate the outgoing NDC members. And he said that. I've cited a Ghana Web article on September 25, 2017, where the general himself was telling us he's invited foreign entities, I think forensic entities, to help them investigate alleged looting that they had made the electorate to believe the departing NDC government had been engaged in. And so what President Mahama is doing with oral is nothing new. The noise about its illegality and unconstitutionality, that noise is new. But the concept itself of investigating an outgoing government is not new, and it will probably continue for the rest of our lives.
When President Kufuor set up the anti-corruption entity within his office, he was heavily criticized for doing something that was solely self-serving.
People could have criticized it as they are criticizing the oral now, but the criticisms themselves do not mean the activity being engaged in is unlawful or unconstitutional. It will be unlawful if this oral committee started to assume police powers or started to assume prosecutorial powers, then I'll be the first to say, no, you can't do that.
Atachia actually says, for the fact that they are doing what they do with publicity, that is where he has, a disagreement with them, and that's what makes them unlawful. And Professor Kwame Jan agrees with Atachia that modus operandi actually makes them unlawful.
And the unlawful, so what law did they cite as being violated?
None yet. None yet.
Yeah, because they can't cite any law. They can just proclaim that it's unlawful. And I'm telling you that these proclamations are done not because they have any basis in law, but because people don't like the idea of post-regime accountability. But post-regime accountability is a necessity unless we have regime accountability. To the extent that a president clears every wrongdoing, then it is reasonable to expect a new government to go and interrogate some of those matters. That's why I have said that oral, perhaps we should also equally emphasize OPAL. OPAL is Operation Prevent All Loot. Because if you prevent looting in your regime, then when another government comes and it's trying to recover loot, there'll be nothing to recover because you didn't even allow looting to take place.
You describe them like a sort of a CCTV that many of us have in our homes. We are not a police state.
No, well, I mean, of course we are not a police state, but we have police. The police comes in only when there is wrongdoing. People who have not looted, look, they can go around doing whatever they want. But I will not be worried 1 minute because I've not looted. People who have not looted should have nothing to worry about merely because somebody has put in their CCTV. If your neighbor puts CCTV in his or her apartment, why should that bother you when you know you are not involved in any wrongdoing? People are worried by oral because they think oral will investigate or will find things that they have done. Let me give you a quick example. So I learned that someone bought a cantonment land, a plot of land in cantonment for, I believe, 160,000 cedis.
That's correct.
The market value of that property is conservatively around $300,000, maybe more. Now,
we're told about 10.5 million Ghana cedis.
10.5 million Ghana cedis, okay? Now, if you are in that category, then you are saying oral is unlawful, oral is unconstitutional. Why? Because oral is going to get to know that. And when oral gets to know that, then the people are going to be excited and say, hey, take our land back for us. Not only take our land back for us, but someone like me would say, to me, this is even an example of willfully causing financial loss to the state. Because you've taken a state asset that is valued at 300,000 or 500,000 or whatever the number is, and you sold it to your crony or someone for 160,000 cedis. That right there is something that the people should support oral for going around to find things like that. And it's not just the sale of land, it's also the award of contracts. It's also the issuance of bonds. We borrowed a lot of money.
You just mentioned that the president is the one who is vested with our lands, public lands, and he's holding them in trust for us as citizens. In this land matter, we are referring to the former NIB boss. This land was rezoned and then sold. So he bought it lawfully. So what can anybody do about that?
Look, lawfully is not just about procedural propriety. You follow the procedures. Lawfulness has something to do also with good faith. It also has something to do with the role of a fiduciary. The president is a fiduciary. He's a trustee. He holds these assets on behalf of the people of Ghana, and he can't say, I've taken all the lands and I've sold it to my nephew for five cities. No, he can't do that, because as a fiduciary, he's supposed to act in the interest of the principal. We are the principal. He's supposed to act in our interest. So selling land below the market value violates good faith. It violates fiduciary responsibilities. It violates the criminal law on willfully causing financial loss to the state. In fact, the whole reason, the whole rationale for that law willfully causing financial loss to the state was because of sex transactions, such grandmother deals, just such sweetheart deals, where people in authority just check the box and transfer state resources to their runners.
Now, Prof, finally tell us how you propose that oral should come to stay. In less than 1 month, they have received, we are told, in excess of 700 petitions and complaints. We would have been expected that these would have been directed to the police, IOCO, OSP, and the rest of them.
Well, so you asked a good question, and let me reframe the question. The question is, why are these complaints not being channeled to those channels that you mentioned? And the answer has to be, there's a trust deficit. There's a trust deficit. People believe that regimes are so powerful that they are able to interfere with the activities of the police, the IOCO, the SHRAJ, the OSP, say that these agencies are not allowed to act independently like we have structured the law. So that is why there are these 700 complaints that are not being directed to them, because they believe if you direct them to these people, not much is going to happen. They have more trust in the president's committee, that once the president sees it, once the president eyes the wrongdoing or the alleged wrongdoing, somebody is going to do something about it. So the way we institutionalize oral is, one, we can strengthen the accountability agencies, make them totally independent so that people on an ongoing basis can report these matters. Or, as I said, do a form of OPAL, Operation Prevent All Loot. The way you prevent all loot is to have controls, is to empower the Auditor General, and so on and so forth. So those control and detective mechanisms. But if we are not able to do that, then the second best solution is the oral, because once there's a change in regime, then there's going to be some accountability. And that is always going to happen. And like you said, Kufuor had it, and Akufo-Addo had it, and now President Mahama has it. And it's going to be that way because there's too much clearance, too much interference, and so on. Nobody believes that wrongdoing did not occur, for instance, in the Cecilia Dapa's case. And so they are unhappy that, look, a minister of state has over $1 million in her apartment, and yet our laws are not able to hold her accountable for anything. They just don't get it intuitively. It's hard for them to understand. And they believe it's because of presidential interference. That's why they are channeling all these things to oral.
All right, Prof, thank you so very much for your time as always. Professor Kweku Asare is the one that I've been engaging on the law. This is your legal light. It is your health law. And now let me bring on Oliver Barker Vomawo. His group, the Democracy Hub, are organizing a policy conversation on the case for a new constitution. They don't really want the constitution being reviewed and tweaked bit by bit. And they are speaking about what they call from protest to progress, the case for a new constitution and key policy expectations for the incoming government. And you have Professor Jima Boedi Mama V Owusu Abuaje. They are joining that show, that discussion. You have Valerie Ejay Mensah, Professor Kofi Abochi, Jeke Tano, Bashira Kamal, and Dr. Kojo Pumponi Asante. And this is happening at the British Council on the 21st of January. That is Tuesday at 5 p.m. Oliver Bakavomawa, thank you very much for joining us. And let's hear your case about whether or not this entity called oral is not an unconstitutional and an illegal animal.
Thank you, Samson, for having me.
Oral is unconstitutional and it's illegal. That's the opposition from the minority and certain sections of the Ghanaian society. What do you say?
Thank you, Samson. I think that the bigger conversation that a lot of people are trying to have, and a lot of the times we do not have the language to be able to better communicate our anxieties about certain things. And so it always comes down to the framework of legality and what is not legal. But I don't surmise that it's a helpful way to be able to get or to access the conversation, to be able to fully discuss the issues. There's certainly an emotive element about the conversation around oral that scares people. And I understand those anxieties. There's anxieties around whether or not, and we've seen some of this conversation that, can make people apprehensive. Some of the individuals that have been appointed into the preparatory committee are persons who have a lot of public exposure, discuss issues around anti-corruption regularly on national TV, that persons are concerned that there can be a witch hunt element into the conversation. Those are things which we must not poo-poo or not consider as critical in the conversation as we go forward. But certainly, and as you have read, there's clear constitutional mandate for any anti-corruption measures that the government might be inclined to take. And those measures can come whether within the framework of law, or it can come up within the framework of policy, or even practices more generally. And I think that here, we need a combination of all these three in order to be able to be successful in how we pursue corruption and how we pursue anti-corruption. Whether we decide to call it oral, or as the NPP in 2017 called it, the National Asset Recovery Task Force, or whatever framework or language or twist we want to put into it, what we are saying that there has to be a more regularized approach as to how we deal with these things so that it doesn't become gimmicky. And the risk of gimmick is perhaps what we need to be also mindful about, I think.
We have the police, we have the OSP, the latest introduction, we have the IOCO, we have the National Intelligence Bureau. All of these institutions are there to fight impropriety. So where is oral's mandate from legally? That's the question.
So the first thing that we need to consider is that the biggest challenge to the anti-corruption framework of fight in Ghana is being what people perceive to be the body language from the top. So for instance, when in the OSP report, former Special Prosecutor Martin Amidu talked about the president being the mother serpent of corruption, beyond the strong language, what was communicating was that there was not, the body language of the executive was not indicating that they were serious about the fight on corruption. And I think for me, oral is a translation of political will and a presence of mind that we ought to get this right. Now, the framework and the mechanism of it, it hasn't been rolled out yet. Truly, the president has put in place what is called the preparatory committee, saying that anybody who has any information to give should talk to the committee. It's not a framework and it's not a mechanism for implementing oral that has been rolled out. Clearly, that body or preparatory committee, I haven't seen it try to exercise any powers of seizure, summoning, or any of those things that with a mechanism for law enforcement. None of that has happened. Now, we need to be able to get more as to what the preparatory committee is intended to do. The president says they're supposed to receive information and pass it on.
Yes, they tell us that their job is simply information gathering. And I call them a conveyor belt of sort for whistleblowing. But if you don't have the power of arrest or summoning and to demand documentation and so on, and to investigate, what will you amount to? I think that's the question people are raising.
I agree. When you look at so let's talk about the whistleblower framework that you mentioned. several of the bodies and individuals that have been named under that framework do not have any of those powers. So we can, yes, when we are thinking about it within the whistleblower context, then we ought to keep it within that context and recognize that we are not looking to empower any of the individuals under the whistleblower framework to have any of those powers. It talks about chiefs, it talks about religious leaders and all these powers, areas of influence. I think our biggest concern is not that the oral committee, as they have it now, doesn't have any of those powers. But our biggest concern is if this is the entire framework of the government's anti-corruption mandate or how it proposes to deal with the problem of anti-corruption. That is where, for me, it becomes problematic. Because the problem is not that people cannot walk to institutions, or that whistleblower frameworks do not exist. And if that's what the gap the presidency has identified, then it's a weak gap, in fact. I am hoping that, and that's what I've said, that I was hoping that the preparatory committee, in fact, would be reflecting on legal framework. We'll be thinking about how can we retool the institutional framework for fighting corruption. And that is what the work of a preparatory body ought to be doing. Obviously, because we want anti-corruption fight to be not only looking back, but also forward-looking, the mandate of this one appears to be to look backwards, to look at things that have happened before us and then report them. But we ought to think beyond this preparatory committee and think about long-term wise, how do we make Ghanaians more confident in reporting crime? I've heard some of them describe this, or I think the nominee for AG said this is see something, say something.
That's right.
But it portends then that, are we suggesting that what is in fact the preparatory committee is going to be one that will have longevity, that is going to stay forever, so that people continue to see, because we won't stop seeing, and we ought to be saying.
There seems to be that kind of impression or indication that oral, in fact, will not end with the assumption of office of an attorney general, where they will submit whatever information they would have gathered. As we understand from the chairman of the committee, Samuel Okudzeto-Ablakwa, they have received in excess of 700 petitions and various disclosures of impropriety. Does that give an indication to you that there is a certain general embrace for the committee, and therefore the question of it not being a legal creature should not bother the country too much?
I don't necessarily think so. I think that once a new government comes in place, there's definitely a lot of enthusiasm and people who are interested in seeing to succeed. Now, beyond the initial 3 months, the honeymoon period, a lot of that, rush is going to die down. A lot of the people who are reporting are going to be reporting this happening in the past government. The question is whether or not, when things happen with this government, is this the body people will be inclined to go to? That question hasn't been solved, or that issue has not been decided on. And even when I'm using the language of body, it is not in fact a body, right? It's a collection of individuals here. Now, even if the presidency has determined that a big gap that exists is people's confidence to report, then a mechanism for reporting, and if it is an enhancement under the whistleblower framework, then it ought to be clearer, because people are concerned also about what protections exist for individuals that come forward and make reports to this committee. My suggestion is that oral has to move the conversation beyond the initial outburst of, immediate reportage into how do we retool institutions and law to ensure that the corruption fight is better mainstreamed and better reorganized, so that some of the results we are seeing, and I'm talking about the 700 reports as being a result, become a daily feature of Ghanaian democracy, and not the one of emotional excitement about what the presidency is talking about.
On the question of legality, some have suggested that if you paid attention to Article 58, the executive authority of Ghana shall vest in the president and shall be exercised in accordance with the provisions of this constitution. The executive authority of Ghana shall extend to the execution and maintenance of this constitution and all laws made under or continued in force by this constitution. Then it says that the president shall exercise this executive power either directly or through officers subordinate to him. The suggestion is that the president can do this, and in terms of the Whistleblowers Act, Section 3, the people that a whistleblower or any Ghanaian can blow the whistle to include the office of the president. So this may be the president indirectly receiving petitions and complaints of impropriety, but he has decided that this is how he wants to receive it. How does that, come to you?
For me, I think that before the president, when he was president-elect, that I said that there was no conversation around the need for law. Now that he's become president, if this is in fact a framework that is intending on enhancing upon the whistleblower framework, that intention ought to be clearly communicated. And in that regard, individuals that the president appoints must become public officers, because the standards and conduct of public officers are something that is regulated in law. We have individuals who have said clearly that they don't intend to receive public emoluments for the work they are doing. I am concerned, and I want their character to be clarified. In that way, we can also then know how we hold them accountable as agents of the presidency. So far, it seems like a voluntary work.
That's what it is.
Yes. And in that case, it is very difficult to then situate it within the whistleblower framework if it is an operation of the president's or an extension of the president's duty to act as a receiver of complaints. If that's the intention, I think it's a good idea that the presidency will be interested in actually opening up its doors, having an open door policy, we should call it. But and that people can then approach it.
But by the Whistleblowers Act, you can blow the whistle to a chief, to the head or an elder of the family of the whistleblower, to the head of a recognized religious body, a pastor, imam, and so on. So one doesn't have to be an officer of the state.
Now, that view is correct. The question is whether or not, in terms of when we have included these agencies under the law, what do we intend with them for, and how do they go about in actualizing the report? My fear is that a lot of these, bodies and individuals were put there as a cultural mechanism rather than a proper whistleblower framework as it is internationally accepted. Because I am unable to say for sure, in terms of individuals that have blown the whistle, how many of them have come through this framework, and if so, how it ended up. So the fact that we are thinking about retooling the framework for oral doesn't mean that even when we are looking at past legislation, we just adopt them as they are. Effectively, and how we retool them must be something we think about. But if the presidency says it is acting because it is one of the institutions named, then the presidency cannot, the presidency can, let's say, engage National House of Chiefs and says that, you know that you're an agency or one of the individuals that have been named under the Whistleblower Act. How are we coordinating our activities and ensuring that people trust to bring out information? That it is competent to do. My biggest worry is that it shouldn't end there. And if it ends there, I think that is a disservice.
Again, we mentioned that you can also blow the whistle to a member of parliament. And people say, Samuel Kudjeto, who is a member of parliament, is the chair of this body, so to speak. You say, we must say, a collection of individuals. And so somewhat, they have a certain grounding in law to receive disclosures of impropriety and to proceed from there. Let's answer the question of they being unconstitutional, unlawful, or illegal.
None of that is correct. There's a clear constitutional framework for anti-corruption fight. If the presidency is saying that my door to hearing citizens' complaints about corruption is individuals who can be approached, it's on proper legal footing. What we haven't seen, if the committee was engaging in certain acts, then we can get into that conversation. But the committee as it exists, as a framework for the president to receive complaints from everyday Ghanaians, is neither unconstitutional, it's neither unlawful, and is another against any policy or anything for whatsoever. Of course, and as we are engaging, and you and I can engage in a conversation about overall effectiveness, but it's a different conversation from legality. In terms of legality, there's nothing illegal about the president saying that report to me through individuals. You and I can have a conversation about whether or not that filters the process and then there is a risk of the information being disclosed and whether this better protects whistleblowers, it's an entirely healthy conversation to have. But unconstitutionality or illegality does not arise, I think.
Is it lawful, or rather, shall I say, is it proper that president-elect, not sworn in as president, is able to put this vehicle in operation?
I think so. And I think that even political parties, whether they have office or not, can put in place a vehicle for whistleblowing. The Fourth Estate has a hotline for whistleblowing. So the
Ghana Integrity Initiative also has a hotline for whistleblowing.
Exactly. So these hotlines are actually with us. The fact that the president-elect is doing so, it's a good thing because it signals intent. And for me, that's what I want to see more of. Now, there's some whistle that I would choose to blow to Ghana Integrity Initiative rather than to the presidency if it concerns corruption at the presidency, for instance. And that is the multiple avenues for people to whistleblow is rather healthy and must be encouraged, I think.
But the NPP minority are right, are they not, when they say this group does not have the power to summon and so on, and therefore, even if they invite you as a former minister or a former government appointee over some inappropriate conduct suspected, do not attend, and they cannot do anything to you?
It's almost as saying that Oliver Bakavama has no power to summon anybody, so when he calls, you do not attend. Unless I have undertaken any initiative to call anybody to come and respond to me, that conversation is neither here nor there. Everybody is agreed, and nobody has said, in fact, I haven't seen it argued anywhere, that the committee has summoned anybody or is purporting to summon.
They have actually said that they have not invited or purported to invite anybody or call it a summons, and they do not intend to do investigation as is being labeled that they cannot investigate, and that clearly is not their work.
And so anything other than what has been clearly said and there's no proof of would seem that we are trying to paint it with a bad name in order to hang it. Let's be clear in terms of what we communicate, and I think all actors, whether or not it's the NDC or the MPP in the space, must be encouraging and can ask healthy questions about what is the process and how can we ensure due process. But if they haven't purported to have the power to summon anybody, and they haven't done that conduct, doing a press conference and announcing this is already putting it within a particular framework. And I think, for me, that's what I know that anti-corruption initiatives in this country have encountered in the past. And I'm quite mindful about already suggesting that something is happening when it's not happening.
They've been doing what they call the validation process. Somebody is giving them information, they want to validate it, and therefore they move to the site, so to speak. That means they may want to move to someone's home. They may want to inspect someone's vehicle that is suspected to have been stolen from the state. Can they be doing that? Should they be doing that?
If you ask me, I have said that Oral must work discreetly. I am a bit dismayed about the cameras following people around and things like that. It screams gimmick, and I'm worried about that, to be fair. Now, when a complaint has been made to any individual acting on behalf of the president, as they are, I do think that there has to be a level of sorting out and screening. If they choose that they want to go and see whether or not it is reported that a public land has been taken over by certain individuals who has built upon it, and it is to see that, to verify them, whether they are moving together as a committee or sending somebody to look at it, fair enough, as a process of screening. But the whole camera thing and all of that, again, we ought to be mindful of the signaling. We ought to be mindful that we are trying to elicit as much broader public support for this as possible. And that public support must come from established institutions, CSOs, it must come from media. All of them want to be able to get behind it. If we turn this into a gimmick, they would not be able to support it so as to make the process credible.
Right.
That's what we want of. But I don't think the process of trying to screen is ingrained in the process of receiving information.
Right. And finally, let's hear from you. You have expressed disappointment. Immediately you heard that the job of Oral was done upon the assumption of a new Attorney General. Why?
First of all, what was the gap that Oral is trying to fill? Oral says it is an operation to recover all loot, investigate, and recover. Now, we have a committee that has no power to investigate or to recover. So you cannot tell me that what has been promised is done by the President of an Attorney General. You ought to lay out a roadmap, or the Attorney General ought to lay out a roadmap for Oral. So Oral is not this committee, because you have told us that it's a preparatory committee. What was he preparing us for? Those answers we must get. So on assumption of office, if you say that the Attorney General is going to take the lead role on Oral, I understand. And that the Attorney General is then going to lay out a framework for Oral, I understand that. But if you say Oral ends upon assumption of an Attorney General in office, presumably you are telling me that there's no new renewed energy to the fight against corruption and that it's business as usual. That I am mindful of and suspicious of, in fact.
That the group is not a creature of legislation does not make it unconstitutional or illegal, you say?
Absolutely. It doesn't in any way. In fact, the president is entitled to receive complaints. Now, that doesn't end the question, because I am always mindful not to narrow the conversation to legality and non-legality. And as far as legality and non-legality is concerned, it is not illegal. In fact, the president is entitled to do so.
Right.
But we want more, I would say.
Thank you very much. And the members of Oral, including the chairman, have also been quoting this particular provision of the Constitution. That is one of my favorite, Article 41, 41F. And 41 says that the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations. And accordingly, it shall be the duty of every citizen to protect and preserve public property and expose and combat misuse and waste of public funds and property. Thank you very much. Oliver Barker-Vormawo.